See you guys, my name is Kumar, you are watching me. Let's start history video without any further delay. So basically this video is going to be routine of 13th November 2025 and today is Thursday. Also continuous shooting the day of 708th days of routine video gonna be happening. So let's start. So basically today first of all I woke up, then after that I washed my mouth, then after that I clicked a photo of water counter meter, then after that I read a quote that is your biggest enemy is your uncontrolled mind. What a quote! Your biggest enemy is your uncontrolled mind. Right. That's the quote what I read today. Then I went outside and I returned the miso parcel and finally, right. And finally, after very long period of time, after doing the mistake of delivery agent, maybe I think so, I received my refund, right. Then after that I came home. Then at the time of evening I ate food. Then after some time later I went for the sleep. So basically, this is the thing what's actually happening in my today's video. I hope you have really understood this video. If you have understood this video, then kindly please like it, because whenever you like some videos, it really motivates me. I encourage you to upload more and more videos in a very continuous manner. So now I'm gonna start going to talk about the commercial law of the chapter, the Indian Contract Act 1872. So the third question I'm gonna read, that is, Mr. Ajay is unconscious of his mind when he enters into an agreement with Mr. Vijay on 15th July 2022 in the evening to sell his office space to him within 15 October 2022. 2022. Next day, Mr. Ajay declared that he was not well and conscious last night and now he is not willing to transfer the office space to Mr. Vijay. Now, Mr. Vijay is arguing that as Mr. Ajay has already signed the agreement, he will have to transfer the property in his name, decide whether or contract is decide whether the contract is valid, and or what is a sound mind or the purpose of contracting. Describe other disqualified persons. Or Mr. Amal, who is so badly drunk that he cannot sit properly on his chair, enters into an agreement with Mr. Bimal on 15th July 2023 in the evening to sell his office space to him within 15th August 2023. Next day, Mr. Amal declares that he was overdrunk last night and now he is not willing to transfer the office space to Mr. Bimal. Now, Mr. Bimal is arguing that as Mr. Amal has already signed the agreement, he will have to transfer the property in his name. Decide whether the contract is valid and present your expert comment. Okay, let's start. Okay. According to Section 11 of the Indian Contract Act 1872, every person is competent to contract who is of the age of majority according to the law to which he is subject and who is of sound mind and is not disqualified from contracting by any law to which he is subject. According to Section 12 of the Indian Contract Act, a person is said to be of sound mind for the purpose of making contract if at the time when he makes it, is capable to understand the terms of the contract to form a rational judgment as to its effect upon his interests. Thus, if a person is not capable of both, he is said to have suffered from unsoundness and conscience of mind. In the present case, Mr. Ajay was not in sound mind at the time of entering into agreement, which makes the agreement void ab initio. Therefore, the agreement is not valid. Okay. Section 12 of the Indian Contract Act 1872 provides that a person is said to be of sound mind for the purposes of making contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. In this case, Mr. Amal When he made the contract in the evening of 15th July 2023, he was not capable of understanding the agreement and of forming notional judgment as to effect upon his interest. As per the provisions of the Indian Contract Act 1872, Mr. Amal cannot contract while such drunkenness lasts. Therefore, the contract between Mr. Amal and Mr. Bimal is not a valid contract. Okay, so this is the third question. I think it is now very in understanding language, and most of the things I am able to understand. Right now, question 4. Mr. X, a businessman, has been fighting a long drawn litigation with Mr. Y, another businessman. To support his legal campaign, Mr. X enlists the services of Mr. Z, a legal expert, stating that an amount of rupees 10 lakh would be paid. If Mr. Z does not take up the brief of Mr. Y, Mr. Z agrees, but at the end of the litigation, Mr. X refuses to pay, decides whether Mr. Z can recover the amount promised by Mr. X under the provisions of the Indian Contract Act 1872. Okay, let's see the answer. The problem is asked in the question is based on one of the essentials of a valid contract. Accordingly, one of the essential elements of a valid contract is that the agreement must not be on which the law declares to be either illegal or void. Further, Contract Act specifies that any agreements in restraint of trade, marriage, legal proceedings are void agreements. Thus, Mr. Z cannot recover the amount of rupees 10 lakh promised by Mr. X because it is an illegal agreement and cannot be enforced by law. So yes guys, this is all what is actually is here. Now I'm gonna read the fifth question. Write a note on acceptance. Okay. Note on acceptance. To constitute a promise, the intention of the parties must be communicated. One cannot accept an offer which had not been communicated to him. In general, uncommunicated offer cannot result in a promise. The term acceptance means admitting and agreeing to something, to accede to something or to accept something. An offer to enter into legal relations upon definite terms to create legal relations must be followed by an intention of the offeree to accept that offer. In Thavardar Perumal v versus Union of India, the Supreme Court held that before an offer can become a binding promise and result in an agreement, it must be accepted, either by words or acts. A person cannot be bound by a one-sided offer which is never accepted, particularly when the parties intended that the contract should be reduced in writing. A promise cannot bind its make unless the promise has assented to it. Section 4 provides that the communication of an acceptance is complete as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor, as against the acceptor when it comes to the knowledge of the proposer. Right, so till yet what is actually it here, I have discussed some questions on this particular video. For the upcoming videos I would like to talk some or more different questions which is actually I am gonna read from this particular book. Right, also this video is about the routine of 13th November 2025, also continuously shooting the day of 708 days of routine video. Right, and as I already told you guys, if you found any kind of mistake, like whatever I speak in English, if you found any mistake from me, like any grammatical mistakes or any English error mistakes, so kindly please tell me in the comment section. I'll really appreciate it that you're trying to help me to improve my English speaking skill. So this is all guys what's actually happened. I think it's all enough for you guys. So let's end the video guys. See you again. Bye bye.